May I please, Lordship?
Yes, please.
My Lord, I beg to mention at the 4, my Lord.
Yeah.
My Lord, some difficulties, my Lord. After 2 weeks, my Lord, kindly take up.
You are Mr.
R. Ali.
On request made by our early learned counsel for the appellant. List
My Lord,
matter after 2 weeks.
similar in respect to item number 9.
You are here for the appellant.
Lordship. Searching terrain.
Hmm?
Searching terrain. Or for the appellant, my Lord.
You are
9.
If 9 goes lordship, 10, I think 10 is also connected. It's connected with 9, man.
okay. You are appearing on behalf of?
Appellant, my Lord, searching terrain.
Okay. Same order?
Same order.
I am on behalf of
I-
respondent, your lordship. Item number 9.
Okay, Mr.
A Haq, lordship.
A. Haq, learned counsel appears on behalf of the respondent. So 9 in 10 goes.
Goes, man.
May I please, Lordship? Lordship, item number 4 has been mentioned, my lord.
Yeah.
It is connected with item number 5.
Yes, yes. I'm sorry, lordship. It's connected at number 5.
Okay. Okay, then in item 4, you say on request made by Mr. R. Ali, learned counsel for the appellant in criminal appeal 146 of 2018. Huh? This the matter after 2 weeks.
May I please, your lordship? So I beg to mention item number 6, lordship.
Yes.
I appear on behalf of Mr. A.M. Bora, lordship. Kindly the matter may be taken up after 2 weeks, after vacation, lordship.
On request made on behalf of A.M. Bora, learned counsel for the appellant, this the matter after the Bihu vacation.
Lordship. Lordship, similar player, item number 8, lordship. I appear for the
Oh.
respondent number 2 and 3 in item number 8.
Huh,
We have informed the appellant side, lordship.
okay.
Lordship, I am appearing for the appellant, lordship. I am appearing Mr. A.K. Bhuya, lordship.
He's for the appellant in item number 8.
And he has been appointed as amicus curiae, lordship.
You are Mr.
J. Das, lordship. Appearing on behalf of Mr. A.K. Bhuya.
Okay, heard Mr. J. Das, learned counsel appearing on behalf of Mr. A.K. Bhuyan. Learned amicus curiae,
Yes, lordship.
learned amicus curiae. On request made by Mr.
Mr. V.A. Chaudhary, lordship. On behalf of A.M. Bora, lordship. The respondent number 2 and 3.
On behalf on request made on behalf of A. Bora. Learned counsel for respond to and list the matter
After 2 weeks, lordship.
after 2 weeks.
Highly obliged.
May I please, Lordship? I beg to mention here item number 2 of today's list, Lordship.
Yes.
Here, Lordship, I may be allowed some time to prepare some notes, Lordship. Here 17 witnesses are there and 6 appearance are there. So if I can prepare the notes, then it will be easy for me to place the case, Lordship.
Okay, you are Mr.
Yeah, Ahmed, Lordship.
On request made by Mr. A. Ahmed, learned counsel for the appellant, list the matter after
2 weeks.
2 weeks.
How long, Lordship?
May I please, Lordship?
Mm.
I beg to mention item number 3. For hearing.
Oh,
I'm on the behalf of H.R. Chaudhary.
oh,
My Lordship, kindly matter for adjourn for a week.
on request made on behalf of H.R. Chowdhury, learned counsel for appellant, list the matter after 2 weeks. What is this? All gone.
One remains the lordship's part
One
of
remains?
matter. But counsel for the appellant, he came, lordship, he will be coming, my lord. He was there 5-10 minutes back. He said he is having another matter. Lordship, one more matter remains. Item number 7.
7.
What is there?
Item 7.
I'm sorry, lordship.
Item number 1. He is for item number 1. Partner matter.
Yes, but number 1. Learned public prosecutor can start. My part was over. Only I will rely upon some decision in reply. Yes.
Place your decision.
Yes.
Yes, please.
Regarding Lordship, the contradiction, how it is to be taken, learned trial court. Dealt with the PW 3 and 6, taking their 164 statement. Although he did not rely upon their evidence before the court, saying that they were staying with their father, he discarded, but he took a lead from their 164 statement. The 164 statement was never confronted with the PW 3 and 6. Only these were exhibited. Only these were exhibited. And these witnesses were also not declared hostile. Now, this is reported in SCC 2015-9 SCC 588. Also, may kindly come to paragraph 6. Here it is in respect of 161 statement, but principle is law is same. Paragraph 16, Lordship, at page 6.
Para 16.
Para 16. Court cannot suo motu make use of statements to police not proved and ask question with reference to them which are inconsistent with the testimony of the witnesses in the court. The words in section 162 CRPC, if duly proved, clearly show that the record of the statement of witnesses cannot be admitted in evidence straightway, nor can be looked into, but they must be duly proved for the purpose of contradiction by eliciting admission from the witness during cross-examination and also during the cross-examination of the investigating officer. Statement before the investigating officer can be used for contradiction, but only after strict compliance with the section 145 of Evidence Act, and that is by drawing attention to the parts intended for contradiction. Section 145 of the Evidence Act reads as under cross-examination as to previous statements in writing. A witness may be cross-examined as to the previous statements made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. Now 18. Under section 145 of the Evidence Act, when it is intended to contradict the witness by his previous statement reduced into writing, the attention of such witness must be called to those parts of it which are to be used for the purpose of contradicting him. Before the writing can be used, while recording the deposition of a witness, it becomes the duty of the trial court to ensure that the part of the police statement with which it is intended to contradict the witness is brought to the notice of the witness in his cross-examination. The attention of witness is drawn to that part, and this must reflect in his cross-examination by reproducing it. If the witness admits the part intended to contradict him, it stands proved, and there is no need to further proof of contradiction, and it will be read while appreciating the evidence. If he denies having made that part of the statement, his attention must be drawn to that statement and must be mentioned in the deposition. By this process, the contradiction is merely brought on record, but it is yet to be proved. Thereafter, when investigating officer is examined in the court, his attention should be drawn to the passage marked for the purpose of contradiction. It will then be proved in the deposition of the investigating officer, who again, by referring to the police statement, will depose about the witness having made the statement. The process again involves referring to the police statement and calling out that part with which the maker of the statement was intended to be contradicted. If the witness was not confronted with the part of the statement with the defense, which the defense wanted to contradict him, then the court cannot suo motu make use of statements to police not proved in a compliance with the Section 145 Evidence Act, that is by drawing attention to the parts intended for contradiction. Now here it is 164 statement. The witness has not been declared hostile in terms of Section 154 of Evidence Act. So there was no cross-examination, no contradiction was brought. But learned trial court in the judgment itself reduced their 164 statement. I have already submitted a decision. The 164 statement is not a substantive piece of evidence. It can be used for corroboration and contradiction. Now, contradiction having not brought on record while examining the witness cannot be brought subsequently to discard the witness. And there are other witnesses also declared hostile, cross-examined. But their evidence, this hostile part has not been confronted with the IO, which is necessary as per this, which is once it is confronted with the IO confirms that yes, he has stated before me such and such, then it can be used as evidence. Fellowship on other day, as learned public prosecutor has submitted that in the case diary, there is a disclosure statement. When I submitted that disclosure statement has not been proved, so the attempt of the prosecution to show it is a leading to discovery is not admissible in evidence. And I have submitted decision also. Now, learned public prosecutors reply was that there is in the case diary disclosure statement is available. And this is not permissible unless it is legally proved before the court. Now, how case diary can be, how far it can be used and to what, whether it can be used as evidence now on case diary, because it has been a practice to show from the case diary in the appellate. Yeah, it is not permissible in law. It is also 3 judges bench.
Is this important in?
No, Lordship, it is Malkiat Singh and others, 1991 4 SCC 341. Lordship, may kindly come to page 7. There is no paragraph mark. Page 7. of 10. Fourth paragraph, bottom, the evidence on record. The evidence on record clearly shows that the defense has freely used the entries in the case diary as evidence. Here, although it was defense, because defense exhibited in the case diary and marked some portions of the diary for contradiction or omissions in the prosecution case. This is clearly in negation of the and in the teeth of section 172(3) of the code. Section 172 reads as thus: diary of the proceedings in investigation. Every police officer making an investigation under this chapter shall day by day enter his proceedings in the investigation in a diary, setting forth with the time at which the information reached him, the time at which he began and closed his investigation, the place or places visited by him, and a statement of the circumstances ascertained through his investigation. To any criminal court may send for the police diaries of a case under inquiry or trial in such court, and may use such diaries not as evidence in the case, but to aid in such inquiry or trial. Now, 3, neither the accused nor his agents shall be entitled to call for such diaries, nor shall he or they be entitled to see them merely because they are referred to the court but if they are used by the police officer who made them to refresh his memory, or if the court uses them for the purpose of contradicting such police officer, the provision of section 161 or section 145, as the case may be, of the Indian Evidence Act 1872 shall apply. It is manifest from its bare reading that without subjecting to detailed and critical analysis that the case diary is only a record of day-to-day investigation of the investigating officer. We ascertain the statement circumstances, ascertain though the investigation or through the investigation. Under subsection 2, the court is entitled at the trial or inquiry to use the diary not as evidence in the case, but as aid to it in the inquiry or trial. Neither the accused nor his agent by operation of subsection 3 shall be entitled to call for the diary, nor shall be entitled to use it as evidence merely because the court referred to it. Only right given thereunder is that if the police officer who made the entries in the diary uses it to refresh his memory, or if the court uses it for the purpose of contradicting such witness by operation of 161 of the code, section 145 of the Evidence Act, it shall be used for the purpose of contradicting the witness, that is investigating officer, or to explain in re-examination by the prosecution with permission of the court. It is therefore clear that unless the investigating officer or the court uses it either to refresh the memory or contradicting the investigator as previous statement under section 161, that too after drawing his attention thereto, as is enjoined under section 145 of the Evidence Act, the entries cannot be used by the accused as evidence, neither it cannot be used as evidence. If it is cannot be used by the evidence, it cannot be used by the evidence as prosecution also. Here, the accused cannot see the case diary. So in that case, while taking contradiction, they exhibited from the case diary. It is not permissible. So case diary is only for taking contradiction and refreshing memory of the IO. It cannot be used as evidence. So even if the disclosure statement is if it is there in the case diary, it cannot be looked into by this honorable court because it is not legally proved. And case diary is not evidence. An entry is in the case diary cannot be read as evidence. Now only two decisions lordship on proof of documents. This is and because 164 statement was mere exhibited and they are trying to take lead from the 164 statement, and on 106 only, because it will be ultimate answer of learned public prosecutor that under 106 I am to answer.
Hmm.
2011 8 SCC 80 first. In this case, postmortem report was exhibited, but its contents were not proved. Paragraph 21, lordship, 2011 8 SCC 80. Paragraph 21. May I please read? Undoubtedly, the postmortem report had been proved, but that does not mean that each and every content thereof is stood proved or can be held to be admissible. Such observation cannot be termed to be a substantive piece of evidence. Dr. G.R. Sharma PW1 did not even whisper about the same in his statement made in the court, which is the only substantive piece of evidence in law. The court cannot place reliance on incriminating material against the accused unless it is put to him during his examination under section 313 CRPC. Thus, the High Court committed error by taking into consideration the inadmissible evidence for the purpose of deciding the criminal appeals and holding the person guilty who had already been acquitted by the trial court. The postmortem report had been examined at the time of framing of charges. The trial court did not frame any charge under such and such. More so, the witness had never mentioned anything in this respect. Thus, it is beyond any stretch of imagination of any person how such observation could be made with high court. Now, paragraph 23, Lordship, relying upon another decision, 23. In State of Bihar versus Radhakrishna Singh, this court dealt with the issue of prohibitive value of contents of an admitted document and held is under. Admissibility of a document is one thing and its probative value quite another. These two aspects cannot be combined. A document may be inadmissible, yet it may not carry any conviction and weight or its probative value by nil. My reason for submitting this document, this already I have said that section of the statement under section 164 statement of PW 3 and 6 was merely exhibited in their examination in chief. While it is substantive piece of it is not a substantive piece of evidence. Now, therefore, merely exhibiting that documents, its content has not been proved. One thing is, it is a previous statement, its contents has to be orally stated before the court. And second thing is proving it is not a document also. Now, even if it is a document, its contents are also not proved as per the law. Only it is merely exhibiting is not sufficient. Because confusion or suspicion arises from their 164 statement only. Otherwise, there is nothing in the prosecution case. There is nothing. Every circumstances are not proved beyond reasonable doubt. Neither it could be linked with each other. Now, section 106 of Evidence Act, Lordship, that it will be the submission that he died or whatever happened inside the house. Accused was, appellant was with her, etc. These are not proved that accused are with her. Murder or how she died, it is not proved. Anyway, if even then, if it is 106, whether attracts or not, on this I am submitting this decision. This is 2022. 22 5 SCC.
Which case?
This is Shatte Singh and another. Reported in 2022 5 SCC 438. Lordship. Lordship, may kindly come to paragraph 15. It has also dealt with other things, also the circumstances, evidence, etc. I have already other day I have submitted decision, but on 106 I am submitting this one. It starts from Reliance based. The paragraph starts from applying, Lordship. The 106 starts from Reliance. Reliance placed by learned advocate Mr. Mishra. For the state on section 106 of the Evidence Act is also misplaced. Paragraph 15. Okay, I'm reading from the first sentence. Applying the said principle to the facts and present case, the court is of the opinion that the prosecution had miserably failed to prove the entire chain of circumstances, which would unerringly conclude that alleged act was committed by the accused only and none else. Reliance placed by the learned advocate Mr. Mishra for the state on section 106 of the Evidence Act is also misplaced. In as much as section 106 is not intended to relieve the prosecution from discharging its duty to prove the guilt of the accused. In Shambhunath Mehra versus State of Ajmer, 1956 SC 404, this court had amply explained the scope of section 106 of the Evidence Act in criminal trial. It was held in para 9. This lays down the general rule that in a criminal case, the burden of proof is on the prosecution, and section 106 is certainly not intended to relieve it of that duty. On the contrary, it is designed to meet certain exceptional cases in which it would impossible or at any rate disproportionately difficult for the prosecution to establish facts which are especially within the knowledge of the accused and which he could prove without difficulty or inconvenience. The word especially stresses that it means facts that are preeminently or exceptionally within his knowledge. If the section were to be interpreted otherwise, it would lead to the very startling conclusion that in a murder case, the burden lies on the accused to prove that he did not commit the murder, because who would know better than whether he did or did not. It is evident that that cannot be the intention, and the Privy Council has twice refused to construe this section as reproduced in certain other acts outside India to mean that the burden lies on the accused persons to show that he did not commit the crime for which he is tried. These cases are such and such. In the case on hand, the prosecution having failed to prove the basic facts as alleged against the accused, the burden could not be shifted on the accused by placing into service the provision contained in Section 106 Evidence Act. There being no cogent evidence adduced by the prosecution to prove the entire chain of circumstances which may compel the court to arrive at the conclusion that the accused only had committed the alleged crime, the court has no hesitation in holding that the trial court, High Court, had committed gross error. Here also, prosecution has failed to prove that it was a murder. First, there is nothing on record, and that I was with him. PW9, if only PW9 deposition is taken into consideration, she came afterward. There is no other witnesses that she saw she was lying in the bed. There is no mark of injury. There is no bleeding, etc. So prosecution first has to prove that it was a murder. Then 201 will come the counseling. So the circumstances, there is forensic expert report. In Dow, there is no human blood. In that ashes, it could not be determined the sex of the bones or ashes. So there's beyond reasonable, there is always a doubt. Beyond reasonable proof, it cannot be said that wife of the accused was killed by the accused. On the contrary, though, on the last occasion, I submitted that PW 3 and 6 should be discarded because their evidence before the court, because they were staying with the father. But their evidence shows different thing. It belies the prosecution case. Only confusion from their 164 statement. And this is a suspicion. Only suspicion. And I submitted decisions also, the suspicion, howsoever strong, it cannot take the place of conclusive proof. And there is other thing, when there is a two view, the view in favor of the accused has to be upheld. So my humble submission, this conviction is liable to be set aside.
Lordship, may I submit, Your Lordship? First, I have a strong objection as to the submission made by my learned friend that I tried to rely on the case diary, Your Lordship. Because from my experience of 12 years in the as PP, Your Lordship, more than 12 years, I have seen, and this Honorable Court also observed, the IOs for the reasons unknown submits before the court, whatever has been, it's not there in the case diary, Your Lordship. And in the event of the matter, if the Honorable Court desires, the Lordship, on the earlier occasions, also when the Honorable Court desires, Your Lordship, we used to look into the case diary, just to clarify whatever is the submission made by the IOs before the Honorable Court. It doesn't mean that I have relied on the case diary. It's a dangerous part to rely on a case diary, Your Lordship, but when there's suspicion arrives at the minds of the Honorable Court, Your Lordship may go into it. Your Lordship relies on the Tehsildar Singh's case. I have other day, I have given Your Lordship the citations, my lord. And apart from that, your lordship, in the instant case, your lordship, there are two eyewitnesses who happens to be the sons of the deceased as well as the accused person. They have made 164 statement before the honorable court, and thereafter in their substantive evidence, lordship, although they have submitted, they have agreed upon that they have already in 164 statement, they have given a 164 statement, but they have said another story before the honorable court. Lordship, may I take your lordship to the evidence of PW3 first, my lord? Master Ratul Saikia. Page 15 would be relevant, your lordship. They, in their substantive evidence, they have stated that the mother has committed suicide, your lordship. I know accused Bijit Saikia, who is present in the chamber of the court today. He is my father. This is Dipali Saikia, was my mother. My mother was in the habit of consuming alcohol. On the relevant day, my mother chased all of us from our residence, and thereafter she committed suicide by hanging herself. At present, I am staying along with my father. He is taking care and custody of my health and education. At a relevant time, I was present in the Namghar. When I returned back home, I noticed cut injury on the body of my mother. My parents used to quarrel amongst themselves on petty matters. My father is also an alcoholic person. On the relevant day, my father was not present in our house as he came out of the house for his daily walks. I did not witness the incident of hanging as well as receiving cut injury by my mother. On seeing the injury on the body of my mother, I cried for help. I shouted for help to my father. After the incident, police arrived at a residence and was produced before the learned magistrate by police for recording my statement. Exhibit 3 is my relevant statement, wherein Exhibit 3(1) is my signature. Here, cross was declined, my lord. Lordship, but on behalf of Bijit Saikia at page 16, your lordship. My mother was in the habit of consuming alcohol. She committed suicide by hanging herself. My father did not tutor me to give false evidence in the court today. Lordship, but as regards the contents made in 164 statement, it was put to him, they have submitted, it was exhibited. So my respectful submission that it becomes a substantive evidence since it was exhibited, my lord. The 164 statement, which is put to the witness, my lord, they have submitted, they did not say, they did not make any statement before the magistrate, my lord. It was exhibited as Exhibit 3. So, your lordship, it's become a substantive evidence.
Let us see that 160.
Yes, 164 statement of Ratul Saikia at page 86. Lordship, page 87. First, they were put some question to check their competence, my lord, since he was a child witness, my lord. And thereafter, your lordship, the certificate is also given by the magistrate concerned, my lord. After getting the answers from the witness, I have observed that he is able to give rational answer to the questions put to him. Page 87.
Yes.
At daytime on Tuesday last, my father, Bijit Saikia, assaulted my mother with a piece of split bamboo used for construction of bamboo wall, and later cut my mother's hand with a dowel. On being cut in the hand, the bone in my mother's hand got exposed and mother died. After my mother's death, father sat down near her and was uttering incoherent speeches. Ritu and I witnessed the incident when we raised alarm, neighbors came. So here in 164 statement, which was exhibited, put through the mouth of the witness concerned, in the substantive evidence, they have admitted, they have made the 164 statement, it was exhibited properly, your lordship. So it becomes a substantive evidence. Same as in case of lordship, other child witness who is exhibited, who has lordship PW6.
Page.
PW6, my lord. Page 21. Twenty-two is the relevant portion. I know accused Vijay Sakya, who is present in a chamber of the court today. He is my father. Shri Ratul Sakya is my brother. I was produced by police before the magistrate for recording of my statement under 164 CRPC at Tittabur Court. Exhibit 8 is my statement recorded by the magistrate when Exhibit 8.1 is my signature. This is Dipali Sakya was my mother. At the time of incident, I was studying in class 7. The incident occurred in the day hours. On the relevant day, my father, Vijay Sakya, went out of the house to his workplace. Thereafter, in absence of my father, my mother committed suicide by hanging herself. At present, I am staying along with my father. He is taking care and custody of my health and education. I give statement before the magistrate voluntarily. Nobody tutored me to give statement before the magistrate. So here they have talked about the 164 statement. And in his case, your lordship, cross was declined. No cross.
Let us see 160.
Yes, his 164 statement, page 98. Page 99 is the relevant portion. Last Tuesday, my father, Vijay Sakya, assaulted my mother with a lathi at first and thereafter cut my mother's hand with a dao. As a result, my mother died. Afterwards, my father hanged my mother's body with the help of a chadar, a wrapper that reaches from the head to the ankles worn by women. I had witnessed the incident myself. When I raised alarm, people came there and found my mother in dead condition. Afterwards, police came. My maternal uncles also came to the PO. So he has given the entire story.
In his statement, he said his father went out.
Yes. 160 in substantive evidence, they said another story. Your lordship, but in substantive evidence, which was put to the witness in the court, my lord, regarding the contents, lordship, that it was exhibited properly. So they have admitted they have made the 164 statement. It was voluntary, my lord.
In his statement, he said mother committed suicide.
Yes.
In his 164,
164.
he said father hanged my
Yes.
father's body.
Prior to that, he cut his mother's hand with a dao.
Yes.
Lordship,
Some contradiction is there.
lordship.
Some contradiction is there.
Yes, there. But lordship, once it is exhibited properly, once lordship, it is not declined, cross was declined in the court, my lord, it remains as a substantive evidence. They have not denied the contents, whatever they have made before the magistrate. They said they made the statement voluntarily, my lord. So once it was exhibited, it was put to them whether you have made the 164 statement. They said, yes, I have. We have. So my respectful submission is that it would be admissible in evidence. Lordship, then thereafter, your lordship, there was leading to discovery, which was proved by the IO, my lord. May I take your lordship to the evidence of IO, my lord? PW 15. Page 38. May I read your lordship?
Yes.
Please take it. On 2/7/14, I was working as working at Morioni Police Station as attached officer of police. On that day, the then officer in charge of Morioni Police Station named Sri Jugal Kolita received an ejahar from Raman Gogoi and registered a case and directed me to investigate the case. Exhibit 1 is the signature with endorsement of the then officer in charge of Morioni Police Station, which I know. I interrogated the complainant and I went to the place of incident. On reaching the place of incident, I came to know that the dead body of the wife of the Bijit Gogoi was already been cremated. I went to the place of incident on 2/7/14 at Lahingao of Morioni. I recorded a statement of all the witnesses of this case. I seized some remaining part of the dead body, such as bones, clothes, etc. After digging it out from the cremation place, Exhibit 4 is the seized parts of the dead body, and Exhibit 4-3 is my signature. I seized one midda as shown by the informant Bijit Saikia from his house. Lordship, it was shown by the accused person. Exhibit 6 is the scissor list, midda, and Exhibit 6-1 is my signature. I seized one long pant and sporting of the accused. Exhibit 7 is the scissor list, Exhibit 7-3 is my signature. Exhibit 12 is the sketch map, and so is my signature. I also seized one document containing signature of public. Exhibit 13 is the said document. I also seized one Sony camera so-and-so. Material exhibit so-and-so is a DA, as well as material exhibit 2 is the clothes of the accused, which is available at the court today. Thereafter, I sent the seized article to the forensic laboratory. I recorded a statement of all the witnesses of this case and arrested the accused person. Accused Gulab Gogoi and Gunaram Borwa were arrested for causing harm to the evidence in this case. I also sent the witnesses, Ritul Saikia, Anamika Saikia, Babul Saikia, and Ratul Saikia to the court for recording their statement. I submitted charge sheet. Yeah, here he talks about lordship recording a 164 statement, my lord. I submitted charge sheet, my lord. Then to Bijit Saikia's cross, my lord. It is not a fact that Bijit Saikia did not show any DAO and brought it out. I did not send the seized DAO to the forensic laboratory for examination. Later on, he says that he sent the DAO for forensic for examination. Regarding the disclosure statement, your lordship, I have got a decision of this honorable court, a full bench, my lord. 2009 GLT 4.
What is there in the original statement? Here it says, I seized one mid-dow
Yes.
as shown by the
Yeah.
informant.
No, it will be the accused, my lord.
Just check up.
Yes, my lord. Other day I marked it. It okay. Here you can record video.
Name is there, Bijit Saikia name is there.
Vijay second name is
Name
there,
is
but here it says informant.
Bijit Saikia is not informed, he is the
Because
accused.
I'm-
Is that- Maybe it's a typing mistake.
Maybe.
Maybe it-
Informant Bijit Saikia. It's written, my lord, in the original. Informant Bijit Saikia. He is not an informant, he is an accused. Some mistake in maybe dictating. Your lordship. So, 2009 2 GLT 434. Not 434, I'm sorry, your lordship. It would be
2009.
2 GLT 414, full bench.
Yes.
Lordship. Para 55. From the emphasized portion of the observations made above in Bodra's Supra, it becomes clear that to the information which the prosecution relies upon to show that the accused gave the information which led to the discovery of a fact should be recorded and proved. But it is not so recorded, the exact information must be reduced to evidence. Obviously, such evidence would mean oral evidence or some other evidence in the form of audio, visuals, or tape. Nonetheless, what clearly transpires from the decision in Bodras is that even when a statement leading to discovery of fact has not been reduced into writing, such a statement is still admissible in evidence, though the probative value thereof would depend on the facts and circumstances of a given case. Lordship, so even if there is no disclosure statement, it is not reduced into writing, it would be admissible in evidence. Regarding the presence of the accused person, Your Lordship, may I take Your Lordship to the evidence of PW9 now? She's Asha Karmi, my lord, Sharmila Kosh. Her name is Sharmila Koch, my lord. At page 28. She's
Yes.
the neighbor. I know all the three accused persons. Incident took place before 2 years. They reside near my house. I knew the wife of accused Vijit Saikia. On the date of incident, while I was going for my duty, I noticed gathering of people near the house of Vijit Saikia. I went to his house. I noticed Dipali Saikia sleeping in the bed. I noticed his two sons and accused Vijit Saikia there. So presence of these persons, accused person as well as two witnesses, they were there in the residence. I did not see any injury or blood. She was wearing her dress. I touched her hand and noticed that she was taking breathing. She was dead by this time. I did not maybe see other two accused. The dead body was cremated in the courtyard of accused Vijit. The other two accused who are present today are Golab and so and so. I asked the husband of deceased about the cause of death. He replied that he don't know. The deceased was not taken to hospital. She was cremated before police arrived. Distance of accused is at slight distance from my house. Distance of the residence of accused me, why not? I don't know about the affairs of the house of accused person. Lordship, then Vijit Saikia to cross as regards Vijit Saikia. It is not a fact that I did not state before the IO that I asked the accused Vijit Saikia about the cause of death and he replied that he did not know. And this question was put in 313 also. He said he doesn't know about it, Your Lordship. But his presence, when it is proved that he was present at the relevant point of time, it's a burden on him to prove that he was not there, Your Lordship. There's nothing in the entire evidence on record, nothing came out. He could not substantiate himself, Your Lordship. He was not there. But other witnesses, my lord, they said he was there because he did the subsequent part also, Your Lordship, the cremation and all without informing the IO and all, my lord, without informing to the police. So, Lordship, the evidence given by the PW9, it's a Lordship may take into account that she saw the accused person present at the place of when at the relevant point of time. He was there. So, Lordship, the evidence of PW9 coupled with the 164 statement, which was exhibited, Lordship proves that the accused person was very much present at the time, Your Lordship. Lordship, regarding 164 statement, may I take Your Lordship to one Jasmine? 2013, 14 SCC 266.
2000.
13, 14 SCC 266. para 24 onwards.
Yes.
The learned senior counsel for the appellant has urged that statements of certain witnesses were recorded under 164 CRPC before the magistrate, namely Kalam Pasha and Dinesh M. Pillai. They said statements were not put on record before the trial court and the same were not marked. As the trial stood vitiated as the accused has been denied an opportunity to contradict or aforementioned statements of the witnesses, which were made under oath before the magistrate, which though are not in the nature of substantive evidence could well be used for the purpose of corroboration and contradiction. Denial of such opportunity against the request in a fair trial. Clause 4 of Section 207 CRPC clearly provided any statement recorded under Section 164 CRPC shall be made available to the accused along with all the other documents that had been filed along with the charge sheet. The appellant herein was neither urged that the statements recorded under 164 CRPC were not a part of such document before the trial court, nor was any issue raised by him at the time of cross-examination. Of B. Muralidharan Nair, the investigating officer. The same is a question of fact. However, it appears from the documents on record that such documents, if the same were in fact a part of the record, were not marked. The appellant raised this issue for the first time before the High Court, and the High Court dealt with the same, observing. A reading of the judgment of the court below shows that both sides refer to the same in detail, and the court below has also referred to the same in its judgment. It is well settled that the statement under 164 CRPC can be used both for corroboration and contradiction of the author of the statement, and thus did not find this ground worth acceptance. Even otherwise, it appears the statement recorded under 164 CRPC by the magistrate was not in detail. No question had been put to the witnesses whose statements had been recorded, nor an attempt had been made to extract answers from them. And the witnesses were asked by the learned magistrate what they wanted to say, and they had no clue as to what they had to speak. Therefore, they simply spoke what came to their mind at the point of time, whether it was relevant or irrelevant. The witnesses could not be deemed to carry so much of wisdom to enable them to know what are the essential facts they need to state before the learned magistrate. The witnesses whose statements were recorded before the magistrate were simply asked, have you finished? You can go. Then para 26. Evidence given in a court under oath has great sanctity, which is why the same is called substantive evidence. Statement under Section 161 CRPC can be used only for the purpose of contradiction, and statement under Section 164 CRPC can be used for both corroboration and contradiction. In a case where the magistrate has to perform the duty of recording the statement under 164, he is under an obligation to elicit all information which the witness wishes to disclose, as the witness, who may be an illiterate rustic villager, may not be aware of the purpose for which he has been brought, and what he must disclose in his statements under 164 CRPC. Hence, the magistrate should ask the witness explanatory questions and obtain all possible information in relation to the said case. So far, the statements witnesses recorded under 164 is concerned, the object is twofold. In the first place, to deter the witness from changing his stand by denying the contents of his previously recorded statement, and secondly, to tide over immunity from prosecution by the witness under 164. A proposition to that effect that if a statement of a witness is recorded under 164, his evidence in court should be discarded is not at all warranted. Lordship may kindly note that part. Here reference has been given. Section 157 Evidence Act makes it clear that a statement recorded under 164 CRPC can be relied upon for the purpose of corroborating statements made by witnesses in the committal court or even to contradict the same. As the defense had no opportunity to cross-examine the witnesses whose statements are recorded under 164 CRPC, such statement cannot be treated as substantive evidence. During the investigation, the police officer may sometimes feel that it is expedient to record the statement of a witness under 164 CRPC. This usually happens when the witnesses to a crime are clearly connected to the accused, or where the accused is very influential, owing to which the witnesses may be influenced. It has been argued by the learned counsel for the appellant that as the blood group of the bloodstains found on the chopper could not be ascertained, the recovery of the said chopper cannot be relied upon. A failure by the serologist to detect the origin of the blood due to disintegration of the serum does not mean that the blood stuck on the X could not have been human blood at all. Sometimes it is possible, either because the stain is insufficient in itself or due to hemological changes and plasmatic coagulation, that a serologist may fail to detect the origin of the blood in question. However, in such a case, unless the doubt is of the reasonable dimension, which a judiciary conscientious mind may entertain with some objectivity, no benefit can be claimed by the accused in his regard. Once the recovery is made in persons who disclose a statement made by the accused, the matching or not matching of blood loses its significance. In view of the above, the court finds that it is not possible to accept the submission that, in the absence of a report regarding the origin of the blood, the accused cannot be convicted, for it is only because of the lapse of time that the blood could not be classified successfully. Therefore, no advantage can be conferred upon the accused to enable him to claim any benefit, and a report disintegration of blood, etc., cannot be termed as a missing link on the basis of which the chain of circumstances may be presumed to be broken. Then my learned friend has taken up plea. The material witnesses were not examined because one of the person who has informed the informant was not examined. He was not also cited as a witness in charge sheet, but that is immaterial, lordship. Even if certain lacuna is in the prosecution case, lordship, if the prosecution evidence is sufficient to convict the accused person, lordship may upheld the conviction part. My lord. Lordship, my response submission is that your lordship will uphold the conviction, taking into account whatever I have submitted and whatever is on record, your lordship. That is my response submission.
A reply, Lordship. On other day also I pointed, but today the public prosecutor has raised this point that PW 15 IO, he stated, I seized one mid-dow as shown by the Vijit Saikia. Now, seizure witness PW 5. Kindly which PW 5. Page 19, Lordship. At page 20, paragraph 3. He says, police also seized one dow from the upper side of the tin of the house of accused. Where is the leading? He is the witness. IO tried to improve the case, but it is not the case. There is no leading. Now, disclosure statement is mandatory. As just now, 2013-14 SCC 260 has been referred. In that case, disclosure statement was there. There was a disclosure statement. Thereafter, court says that yes, there is no, when it is seized in terms of a disclosure statement leading to a discovery, whether there is a human blood or not, it is not a question, because if disclosure statement is proved beyond reasonable doubt, if it is admissible, it is not required. Now, in our case, there is no disclosure statement proved in this case. PW 15 and PW 5 are inconsistent with each other, leading to leading. Secondly, on other day, I submitted 2 decisions, Lordship, regarding leading to discovery. I'm not repeating, just I'm referring this. This 2011 SCC 724 and 2010 6 SCC 525. In 2010, it has been said the disclosure statement is required. The recovery should be in terms of 2010 6 SCC 525 at paragraph 20. For effecting a discovery, a statement has to be recorded on the part of the accused, showing his readiness to produce the material object, and it is only the part of the statement which is not incriminating and leads to the discovery which becomes admissible. And other one, I relied upon 2011 SCC 74, 724. There at paragraph 25, it is clear. Only leading to discovery is not enough. Paragraph 25. With regard to the section 27 of the Act, what is important is discovery of the material object at the disclosure of the accused, but such disclosure alone would not automatically lead to the conclusion that the offense was also committed by the accused. There, in fact, thereafter, burden lies on the prosecution to establish a close link between discovery of the material object and its use in the commission of the offense. Paragraph 25 at 2013, 11. What is admissible under section 27 of the Act is the information leading to discovery and not any opinion formed by the prosecution. So how prosecution links with there is no disclosure statement? And every circumstance has to be proved beyond reasonable doubt. It is not something there, and a conviction will be happened. Suspicion may arise. There may be suspicion. And another important thing, learned public prosecutor has conveniently referred to PW3 and PW6, taking their deposition. Now, if their deposition before the court is to be taken, my submission was fair in terms of their child witness, as they were staying with the father, their entire evidence will go. That was my submission, and I referred one decision also. But their evidence is in my favor. They stated, I was not at home, which is corroborated by PW13, 313 statement also. I was not at home. If their evidence is to be taken, it is to be taken in toto. Not one part for the convenience of the prosecution, and which is for advantage of the accused has to be. This is the law is clear that when there is two view in favor of the accused has to be taken into consideration. It will be referred. Secondly, submission was, again, I already submitted this, 164 is not substantive piece of evidence. The judgment relied upon her also says the same thing. But if I correctly follow, her submission was that it is a substantive piece of evidence because it was exhibited. That's why I submitted that decision, Lordship, that is the regarding post-mortem report, mere exhibited. Mere exhibiting a document, it does not. And 164 statement is for corroboration and contradiction. It does not, it cannot, it is not a document. It is per se, it is not a document. It cannot be, it is a document, it is a statement. It has to be proved by bringing on record whatever has been stated therein. And if the witness does not support whatever stated, it should have been declared hostile. For bringing a contradiction by the, it can be only contradiction can be brought only in cross-examination. Only by a cross-examination. So this is not the correct proposition of law, what has been suggested, Lordship. It's my humble submission that it becomes mere exhibiting, it becomes substantive piece of evidence. And PW9, regarding PW9, it has been submitted that he was present there. PW9 found accused, how? When she went there, it is after death. We are dealing with murder. After death, he found her sons, their sons, and the accused is there. On her body, no injury mark. This is an important witness. This is a prosecution witness. If that be so, what are the links, others links? This is the prosecution case. It is a blastine. The dhow was seized. Serologist found no blood. It is the prosecution case. Ashes were seized. It was not determined whose ashes is a male or female body. So my humble submission, prosecution has failed to link all the circumstances to form a complete chain. In a circumstances evidence, otherwise it is not possible to conclude that And nowadays, Lordship, we know it is a beyond reasonable doubt. Supreme Court time and again says unerringly. Unerringly, it can be concluded that accused has committed the crime. So my humble submissions, it is a fit case to interfere with. Lordship.
Can you prepare short
Lordship,
submission?
Lordship,
Written
synopsis.
fourth part.
Lordship.
Myself also, my lord.
When can you? submit?
I will try day after tomorrow. Lordship.
Lordship, we can give it by preparing and give it to the bench clerk, my lord. Lordship,
We'll list it after tomorrow. You
Yes, Lordship.
hand over.
Lordship.
yes.
Better.
Regarding the non-examination of material witness, may I refer one judgment, 2013 7 SCC 45.
You are referring to?
2013 7 S. I'll give the citation, man. 2013 7 SCC 45. Para 24. Para 24, and regarding the non-explanation, failure to offer explanation, para 28 of the same judgment. Para 28. Non-offering explanation. Lordship, I'll give the citation, your Lordship, later on. Lordship, so your Lordship will take out the shape from the grain, your Lordship, in order to come to a conclusion, my lord.
I'm just curious.
Yes, Lordship. Amicus.
Be buoyant. It is.
And he-
30 part. Day after tomorrow,
Lordship,
Lordship. Public.
30. 30.
Three.
That way, no hearing, just
Yes.
Yes,
I will submit this. Public.
Item 7.
May please, your lordship. Your lordship, the learned senior counsel, Jet Kumar, arguing this matter, my lord, he is out of station, my lord. So it may be taken up on 25th or 27th of April, after Ramzan, my lord. As per instruction, my senior, my lord. 25th or 27th of April.
you
my
could
lord.
have submitted a mention slip.
No, my lord.
You should have done it. Notification is already there. At least one day in advance.
No, no, no.
You're making this. You are aware of the notification, isn't it?
That is not I am aware, my lord.
Everybody is making mention slip.
yes, my
You
lord.
are the only. You have any objections?
Lordship, since he's out of station, my lord.
After Ramzan, my lord,
When is Ramzan?
it Ramzan, end of Ramzan is 22, my lord. It will fixed on 25th or 27th, my lord, of April.
Okay. On request, Madam, of Mr.
F.A. Hassan. F.A. Hassan.
No, you're making on behalf of Z Kamar.
Jet Kumar, yes.
Just come up, then it comes. Then it comes, yeah. That's all. Twenty-seven.
27. Obliged to not.
April.
Obliged.
That's, be where.
Obliged.